Court's back in session. First case on our trial docket is cause numbers, at least the first two cases, are cause numbers 321225 and cause number 327795. Both cases are styled the state of Texas versus Russell. At least the first case is styled the state of Texas versus Russell Bean. The second case is styled the state of Texas versus Russell Thomas Bean. Mr. Bean, is that your full name?
Yes, sir.
Mr. Bean, would you please raise your right hand? Mr. Bean, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Bean, you may put your hand down. How are you doing, Mr. Bean?
All right.
You doing all right? And Mr. Bean, you're here represented by your attorney, Attorney Dustin Galmore. Attorney Galmore, how are you doing?
Great, Judge. How are you?
I'm doing fine. And state is represented by Attorney Lamar Johnson. Attorney Johnson, how are you doing?
I'm blessed, Your Honor. Thank you.
Mr. Galmore, we have a okay. No, I was just saying if she was taking a record. Mr. Bean, in cause number 321225, I have before me an information that alleges that on or about November 23rd of 2018, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed to Class B misdemeanor offensive driving while intoxicated. Mr. Bean, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Bean, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Okay, Mr. Bean, I have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there are a set of initials on the line next to a box that's checked nola contendere. Mr. Bean,
Yes, sir.
these are your initials. On page 3 of the same document, there's a signature above the line that is titled defendant. Mr. Bean, is this your signature?
Yes, sir.
On the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? There are two boxes that's checked at the top of this document. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes, sir.
The second box states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that? Mr. Bean, I also have before me a document that is titled Discovery Certification. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Mr. Bean, before you signed and initialed these documents, did you read the documents?
Yes, sir.
And did you understand what you read?
Yes, sir.
And did your attorney go over these documents with you?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Bean, are you a citizen of the United States?
Yes.
State, I have before me State's Exhibit number 1, the misdemeanor plea admonishment, and State's Exhibit number 2, the probable cause affidavit, which is in the court's file. State, you'd like to offer States 1 and 2?
Yes, Your Honor. State offer States 1 and States 2.
Any objections?
No objection.
No objection. State's Exhibits 1 and 2 will be admitted into evidence. Mr. Galmore, you have advised and counseled Mr. Bean. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Bean, your attorney, Mr. Galmore, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided fully effective and competent legal representation?
Yes, sir.
Mr. Bean, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
Your Honor, in exchange for defendant's plea of no contest in this case, the state is recommending confinement in the Jefferson County Jail for a period of 180 days, Your Honor. We're asking that the court suspend imposing that sentence at this time and instead place defendant on community supervision for a period of 1 year, require defendant to pay a $500 fine and to complete 80 hours of community service. And in connection with this plea agreement, Your Honor, the state is moving to dismiss case number 327795. And we're asking for the standard terms and conditions of DWI probation.
Okay, Mr. Bean, the state is offering that you serve 180 days in Jefferson County Jail. However, you will not be required to serve any time in the Jefferson County Jail on this case because you'll be placed on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $407, which comes to a total of fine and court costs of $907. You will also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You'll also be required to pay Jefferson County DDI education class an initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you will be able to pay, that you'll be required to pay while you are on probation, is $160 a month. Mr. Bean, will you be able to pay the $160 each month?
Yes, sir.
You'll also be required to perform 80 hours of community service. You'll be required to attend and complete a DDI education class and have a drug and alcohol assessment. You'll also be required to adhere to the other standard terms and condition of this probation. The state will also be dismissing clause number 327795. Mr. Bean, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, Your Honor.
Mr. Bean, I'll follow a plea bargaining agreement that you have entered into with the state. Mr. Bean, you're gonna stand on the X next to your attorney, and you're gonna follow our court clerk's instruction. Once you finish following her instructions, you'll be free to go and you have a blessed day.
Thank you.
You're welcome. Next case is cause number 327450. and cause number 331-290. Both cases are styled State of Texas versus Robert Adam Goff. Mr. Goff, would you please come forward? Mr. Goff, in cause number 327-450, your full name is Robert Adam Goff.
Yes, sir.
Mr. Goff, would you please raise your right hand? Mr. Goff, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Goff, you may put your hand down. Mr. Goff, you here represented by your attorney, Dustin Galmore. State is represented by attorney Lamar Johnson. Now, Mr. Goff, I have before me a document. Now, I just swore you in. Did I swear you in?
Yes, sir.
Okay, Mr. Goff, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that in cause number 327-450, that you, Robert Adam Goff, on or about November 29th of 2019, while you were operating a motor vehicle in a public place in Jefferson County, Texas, that you committed the class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Goff, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Goff, how do you plead? Guilty, not guilty, or no contest? Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Mr. Goff, I also have before me a document on this tablet that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there are a set of initials on the line next to boxes checked no contingent, which means no contest. Are these your initials?
Yes, sir.
On the next document, on the same document rather, but the next page, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
On the next document, this document is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
There are 2 boxes that's checked at the top of this document. The first box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that? The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Yes, sir.
And Mr. Goff, I also have another document here. This document is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? Mr. Goff, before you signed and initialed all of these documents that I've just showed you, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Goff, are you a citizen of the United States?
Yes, sir.
State, I have before me States Exhibits 1, the misdemeanor plea admonishment, and States Exhibit 2, the probable cause affidavit, which is in the court's file. State, you like to offer States 1 and 2?
Yes, Your Honor. I'll take 1 and 6 too. No objection.
No objection. States Exhibits 1 and 2 are admitted, and court will take judicial notice of States Exhibit number 2, which is in the court's file. Mr. Galmo, you have advised and counseled Mr. Goff. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
Mr. Goff, your attorney, Mr. Galmore, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided fully effective and competent legal representation?
Yes, sir.
Mr. Goff, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is that agreement?
Your Honor, in exchange for defendant's plea of no contest in this case, the state is recommending confinement in the Jefferson County Jail for a period of 180 days, Your Honor. We're asking that the court suspend imposing that sentence at this time and instead place the defendant on community supervision for a period of 15 months, Your Honor, requiring him to pay a $1,000 fine to complete 80 hours of community service. Also to pay $60 restitution to the DPS lab.
You say $60 restitution,
Yes, sir.
DPS, okay.
We're asking that the standard DWI conditions include a interlock device, Your Honor. And in connection with this case, the state has moved to dismiss case number 331-290.
Dismiss. 321. 33290. Okay, I'm looking at this here. Is this 72 hours?
Oh, yes, sir. My apologies, Your Honor. Mr. Goff will surrender himself to start his 72-hour mandatory sentence on what was it?
You say, hold on a minute.
420.
Wow. This is not a DWI second. It's not a mandatory.
No.
So it's just a condition of his probation.
It's just a condition, 3 days condition.
Okay,
To
so
start on
we're
420.
right. So so you're gonna do. Okay. So is he okay?
He wants to start at 420 of 23 at 6 p.m.
4/20/23 at
6 p.m.
or before 6 p.m.
Yes.
Okay. Let me make sure I got that. Yeah, I'm gonna have to put that in there. The date that he's supposed to start. I'm gonna have to be in the judge. Okay, okay. Now, Mr. Goff, the state is offering. You said 180 days?
That's 1/1, I think. 1/15 months.
1/15, Your Honor.
Oh, okay. So I thought you said, okay, I wrote 108. You said it. Okay. Okay, so that's 365 days, which is a year. Is that correct?
Yes, sir.
Okay, we'll have to make that change. Yeah. He must have did he write that on,
He put there 65.
let's see, oh, I see, he has a year over 15 months, yeah.
Yes, sir.
She's got it right.
No, she had it right.
Yeah.
I think he said 180.
I did.
Okay, now, Mr. Goff, in clause number 327450, the state is offering that you serve 365 days in the Jefferson County Jail. However, this will be probated for 1 year. That means that you'll be on probation for 1 year. During the 1 year probationary period, you'll be required to pay a fine of $1,000 plus court costs of $402, which comes to a total of $1,402, a total of fine and court costs. You'll also be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month. You'll also be required to pay Jefferson County DW Education an initial evaluation fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you'll be required to pay each month while you're on probation, is $180 a month. Will you be able to pay the $180 each month?
Yes, sir.
You'll also be required to perform 80 hours of community service. You'll be required to attend and complete a DW education class and have a drug and alcohol assessment. You'll be required to install a DWI interlock device on any vehicle that you own or operate. You'll be required to pay restitution to DPS in the amount of $60. You'll also be, your companion case of 331-290 will be dismissed as part of this plea bargain agreement. Now, you will also be required to serve 72 hours upfront, 72 hours of, as a condition of probation. And that 72 hours in jail as a condition of probation will start on April 20th, 2023, at or before 6 p.m. Okay, now, as I mentioned earlier, you also be required to install an interlock device on any vehicle that you own or operate. Now, Mr. Goff, do you understand? You will also be required to adhere to the other standard terms and conditions of this probation. Now, Mr. Goff, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay. Mr. Goff, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Goff, you're gonna stand on the X next to your attorney and follow the directions of our clerk. And once you finish following her directions, you'll be free to go, and you have a blessed day, Mr. Galmore. You'll be free to go as well. And you have a blessed day.
Judge, you too.
And Mr. Galmore, it's gonna take us a while for these dismissals to get out.
That's fine.
It just takes a while on the print now. But I'm
So you just give the seat.
Yeah, that have the white, State, are you ready? Defense, are you ready? Okay. Mr. Bailiff, would you please, call in the jurors? That's right. Would you please come forward? Go past the wall and go all the way down, all the way, now past the wall.
Absolutely.
Yes. And you gotta go all the way, take that last seat on against the wall and you just. That's Hop.
Yes.
So I'll take that seat right there that you just passed. Let's go, Florida. So Davis, just come on forward. You're gonna take that first row right there, all the way to the end, the seat with the black and yellow tape on it. And Mr. Cerna, you're gonna take the next seat on the same row with the black and yellow tape. Tommy Jones, that row right there, no, the one you spot. Yeah, I'll go all the way down to the end, and you're gonna take that seat on the, against the wall. You're gonna follow him, no, okay. Just straight down there, you're gonna take that seat against the wall, and sir, just keep walking. Yeah, that's your chair, and then right there, the chair right there, sir. And then is that Kellerman?
Yes.
Keep walking, you're gonna take that seat, the black and yellow tape. And then, Mr. Bird, take that seat right there. Yes. And on. Okay, Christopher Kozlowski, that chair where your hand is, walk up one. Right there. You're gonna come, on that row and walk all the way down to the end. And go to that second row of seats and the seat with the black and yellow tape on it. Keep walking. Is that Dupree or Dupuy? You're gonna stay in that same row, you're gonna sit in that chair with that black and yellow tape on it. Mr. Hahn, you're gonna sit in the chair next to the officer, right there? Yes. What? Is that Kimberly Ezel? You're gonna take that last row, go all the way down to the end where that chair has the black and yellow tape on it. Right there. Any Gibson? Rick, Holland? Lauren Davis? Benny Gibson? Okay, you take that last row and you're gonna walk down to that chair that has the black and yellow tape on it. Rick Holland, you're gonna take that chair right there where you're standing. No, in the back, behind you with the black and yellow tape. And then Lauren Davis, the chair that you're standing by. You may be seated. That's everyone. Okay. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence L. Holmes. I'm the presiding judge here in County Court at Law number 2. First of all, on behalf of Jefferson County Court at Law number 2, citizens of Jefferson County, I'd like to welcome you to County Court at Law number 2. Jefferson County Court at Law number 2 is the misdemeanor court. We handle criminal cases, and those cases are misdemeanors. Criminal cases are divided into either felonies or misdemeanors. Your felony cases are your more serious type cases, whereas your misdemeanors are not as serious. They are commonly referred to as petty offense, but it does not mean that they are not serious. They're not as serious as a felony offense. Now, you have been asked to come to court to serve as jurors in a criminal case this week. You will be examined for inclusion on a criminal case, a misdemeanor criminal case, and our courtroom hours normally vary. In County Court at Law, normally the courtroom hours are 9 to 5 p.m. And so each day when you break in a recess, the court will let you know when you need to come back to court. Because sometimes we have other activities in the morning. We may require you to come back at 1:30. If we do not have any activities, other court activities in the morning, then we'll probably require you to come to court probably at 9 a.m. But we'll let you know when you need to come back at the end of each day. Whether or not you're selected as a juror in a criminal case, you are performing a service which is very significant and only free people can perform. If you are selected, the case will be tried expeditiously, consistent with justice, which require a careful and correct trial. If selected on the jury, unless instructed otherwise, you will be permitted to separate at recess for trials and at night. I have an administrative matter that I must attend to before administering to you the first of 2 oaths. Now, I'm going to ask, first, we're going to ask each and every one of you to raise your right hand. And then after I administer the first oath to you, then please say, I do. Do you and each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions touching your service and qualifications as a juror, so help you God? All right, you may put your head down. The law requires that each of you must possess certain qualifications before you may be considered for service as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would determine if all of you possess the qualifications for service on a criminal jury. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you are seated on a jury, the case could be retried and you may be held in contempt of court and placed in jail for up to 180 days and fined up to $500. Now, before I ask you the questions, I'll just tell you basically how I'm going to ask the questions and then what we are going to do in requiring you to answer the questions. Now, first of all, I'm going to ask the questions. I don't want each and every one of you to answer the question, just answer it to yourself. And at the end of me asking you those questions, I will ask if anyone feel as though that they're disqualified under the law. And if you think that you may be disqualified under the law, I will ask that you will raise your hand. You will raise your hand, and then we're going to ask that you will come up to the bench. This is the bench, so that we can discuss the matter more privately outside of the hearing of the other jurors who are on the panel. And I will play this device so that whatever we discuss would not be heard by the rest of the panel. My first question that I need you to answer to yourself is this. Except for failure to register, are you a qualified voter in Jefferson County and in the state of Texas under the Constitution and laws of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, the next question, I always pause to explain that this next question that I'm going to ask, we're not trying to pry into your personal affairs, but it's a question that I'm required to ask by law. And this question is as follows. Are you insane? Are you presently insane, or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and resident of this county, Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 6 months in a county court, or 6 days in the preceding 6 months in a district court? Is there anyone here who feels as though that they may be disqualified under the law? If you think that you may be disqualified, just please raise your right hand. Let the record reflect that no one have raised their right hand. So at this point, everyone are qualified. Now I will determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just please continue to remain seated. Now, I will ask these questions in the same manner that I asked the other questions. First question, are you over 70 years of age? Do you have legal custody of a child or children under the age of 12 years, and jury service would necessitate leaving a child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher learning? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in the county during the 3-year period preceding today's date? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Are you a member of the United States military forces, serving on active duty and deployed to a location away from your home station and out of Jefferson County, Texas, your county of residence? If any of these exemptions apply to you and you would like to claim them, please raise your right hand. Let the record reflect that no one on the panel is claiming an exemption. Now I will move to excuses. If any of you feel there's a reason why you cannot sit as a juror, then once I finish with the excuses, then you can raise your right hand and we could come up and discuss that matter more privately. As a juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties. That is, without the consent of the district attorney's office and the state and the defense. A juror who, without prompting articulates an inability to listen to testimony or be fair and impartial may be excused. Is there anyone on the panel who is claiming an excuse? Please raise your right hand. Let the record reflect that no one on the panel is claiming an excuse. Let the record reflect that all the jurors are qualified. No juror is claiming an exemption, and no juror on the panel is claiming an excuse. This is cause number 331042. The case is styled the state of Texas versus Leo Randall Jr. Let the record reflect that the defendant, counsel for the defendant, counsel for the state, and all members of the jury panel are present. The defendant in this case is Mr. Leo Randall Jr. He's sitting at the table in front of me with the blue shirt, and he is represented by his attorney, Mr. Thomas Roebuck. The state is represented by assistant criminal district attorneys. Sitting first chair is attorney Lamar Johnson, and sitting second chair is attorney Colby Hoffpower.
Good afternoon.
Our court reporter in this case is Miss Ada Christie, and she will be taking down everything being said, so speak up when you are being asked questions. The bailiff today is Mr. Otis Butler. Mr. Butler, you met him earlier. The defendant, Mr. Leo Randall Jr., stands charged by information with the Class A misdemeanor offense of deadly conduct. The range of punishment upon conviction for a Class A misdemeanor is confinement in jail for a term not to exceed 1 year, a fine not to exceed $4,000, or both such fine and confinement. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up to the bench so that we can discuss the matter more privately. And the court will put on the noise device. Is the state ready to proceed?
Take it, Your Honor.
Is the defendant ready to proceed?
Yes, Your Honor.
Mr. Johnson, the panel is yours. Please limit your examination to 30 minutes.
Yes, sir. Your Honor, you mind giving me a 5-minute warning?
Yes, I'll give you one.
Thank you, Your Honor. May it please the court, counsel. Good afternoon, ladies and gentlemen. My name is Lamar Johnson. I'm the assistant criminal district attorney here, Jefferson County District Attorney's Office. I'm honored to stand here before you with my co-counsel, Assistant District Attorney Colby Hoffpower, on behalf of the state of Texas and the citizens of Jefferson County, to have 6 of you decide this very important case for us. In this part of the trial, we need to know your feelings. your impressions, your opinions, about the issues in the case. They all have to say, it's a safe space, and we just want you to be honest. The defendant, as the judge said, the defendant is charged with deadly conduct. I'll get a bit more into the law a little later, but my questions will be about deadly conduct. So I wanted to be upfront and transparent about where I'm going, where my line of questions are going, so you're not just wondering why I'm back. I promise, we promise to be honest with you, and we ask only that you be honest with us. There are no right and wrong answers at this part of the trial, but what's important is that you all be truthful. You could took an oath, tell us the truth, and we're just asking that you honor that oath. The court fortunately provided us with a nifty little cheat sheet here of telling us a little bit about each of the jurors. For example, Miss is it Imhoff? You're a caregiver, correct, with Synergy Home Health. Okay, and Mr. Burton, you're a firefighter with Port Arthur. And Mr. Saladin, okay. You have a kid who's a pro basketball player. When did you know that you couldn't stick with him anymore? At what age?
Oh, probably about the time he was a senior in high school. But beat him up pretty good before that.
Okay, so just to be fair, I want to tell you guys a little bit about myself. I'm originally from Houston, Texas, born and raised by a wonderful and lovely grandmother, the littlest lady of me. I'm first generation college student, went to A&M for undergrad, then went to U of H for law school. Well, in undergrad, I was a political science major, and economics minor, and Africana studies minor. Went to U of H for law school. And then after law school, I clerked with 2 federal judges. My first stop being here for Judge P.F. Gilman, who is now the district attorney. I then went to Sherman, Texas, clerked with Judge Mazant. And after spending a couple of years not getting any sleep doing civil work in Houston, I called Judge Gilman and asked him if I come keep Beaumont and Jefferson County State Forums and help prosecute some of these cases. And he unfortunately obliged. So here I am for you guys, a fairly new prosecutor, but thoroughly doing what I do. I just have some preliminary matters, in addition to what the judge kind of monitor you guys on. Do any of the jurors, do y'all know anybody else on the jury panel? Okay. And with, let's see here, Mr. Davis? Yes. And Mr. Lawson? And, okay, yes. Is there anything about the nature of your relationship that would prevent you guys from being fair and impartial jurors on this? I'll start with you, Mr. Davis. Yeah. What about you, Mr. Kozlowski?
No, not at all.
Again, I'm a fairly new prosecutor, but that's supposed to be a rarity, but it has happened a few times, more than a few times in this court, so I guess it's a lucky court. Anyone else? There anyone else? What about the judge? Does anyone know the judge? Is familiar with the judge?
Yes.
Kobe Hawkfire? Or is there anyone in the room? Please raise your hand if you recognize anyone in the room, of course, except for you all today. Let the record reflect no one. I want to start with the burden of proof in this case. I want to start there because the buck kind of stopped there and the buck stopped with us. Our job here is to, do our case beyond, and each element of our case beyond a reasonable doubt. That is the standard, beyond a shadow of a doubt and things like that. That's just for TV. Our burden is to prove our case, each element of our case beyond a reasonable doubt. Mr. Jones Jr. What do you take beyond a reasonable doubt from me?
Set that proof, I guess.
Okay, what about, Mr. Holmes? What do you take beyond the phrase beyond a reasonable doubt? I'm sorry, sir. What do you take the phrase beyond a reasonable doubt to mean?
The fact that Joel would be true, then no doubt in my mind that they are true.
Okay, thank you for that. I just want to follow up on that for just a little bit. You said no doubt in your mind. Do you think reasonable doubt means beyond all doubt? Beyond all reasonable doubt, do you take that? And again, there's no right or wrong answers here. I'm just kind of getting a feel of how everyone feels about what we have to do, our responsibility. So beyond a reasonable doubt, do you take that to mean beyond all doubt in your mind?
No,
Okay, so would it be fair to say, just beyond whatever you think is reasonable, beyond a reasonable doubt?
yeah,
Would it be fair to say, it's not beyond all doubt? You're not saying that you absolutely have to, beyond all doubt.
yeah.
Actually, let me back up. If it wasn't beyond all doubt, how would you know something was beyond all doubt?
We have to listen to the testimony and the facts and make a judgment.
Would it be fair if I said, that something was true beyond all doubt, you probably have to be there? Beyond all absolute doubt whatsoever, would it be fair to say, would it be fair for me to say, for you to know something beyond all doubt, you probably have to be there?
Yes, I think.
Okay. Thank you, Mr. On. And I think that's a common misconception, is that we need to prove our case, or any prosecutors have to prove their case beyond all doubt. That is, if you knew beyond all doubt that something happened, you were probably a witness, and you wouldn't be sitting in the jury panel, they're on that stand eventually. So our standard is lower than beyond all doubt. Mr. Cern, I ask you the same question. What's reasonable doubt to you? Or what do you take reasonable doubt to?
Testimony makes sense.
Okay. And I could say that, almost anything that you come up with is going to be a correct definition. That's because there is no exact definition of what reasonable doubt is. It's personal. It's whatever is reasonable to you due to your life experiences, your interpretations of things, of facts, of this everyday life. Whatever you feel is reasonable, that's what beyond a reasonable doubt is. We only ask that you don't leave your common sense at the door when you come in here. I think a lot of jurors, in my experiences, kind of sit in that seat and listen to the judge and get these formal instructions, and you have a bailiff here and have defendant and prosecutors, and we all kind of forget that we live normal, regular lives as regular people, and we understand if something doesn't pass the smell test. And I'm just asking that we don't leave our common sense at the door when getting and analyzing testimony and facts that we're going to present. Do you think that's something you can do, Ms. Is it Ezel? Okay. Do you think that's something that you can do, listen to the fact of the case and determine whether we have met our burden of proving, each element of the case beyond a reasonable doubt? Thank you. Okay, I'm gonna get into the law just a little bit. As the judge stated, the defendant is charged with deadly conduct. Specifically, the information alleged that the defendant, on or about certain dates, in Jefferson County, unlawfully and recklessly engaged in conduct that placed the complainant in imminent danger of serious bodily injury. I'm gonna run through that one more time, because each of these elements is an element we must prove beyond a reasonable doubt. That one, the defendant, two, on or about a certain date, three, in Jefferson County, Texas, four, unlawfully and recklessly, five, engaged in conduct, and six, that placed the complainant in imminent danger of serious bodily injury. Here, simply alleged that the defendant pointed a gun at the complainant. So I want to given that brief recitation of the elements and what kind of briefly this case is about, I want to get your feelings about this type of conduct. And again, there's no right or wrong answer. Ms. Haberman? Anyone see here? Ms. Haberman, have you or anyone you know ever been involved in a case of someone maybe pointing a gun at them, or have you had a gun pointed at you? What about Mr. Ryan? What about you? Have you been engaged in been a part of a situation where someone pointed a gun at you?
Yes.
Okay, and okay, how did that make you feel, if you don't mind? That
I felt threatened.
and were the police called?
No.
Is there a reason the police weren't called?
Traffic incident.
Oh, because you're riding in traffic and road rage, type of road rage.
About 40 years ago.
And anything about that experience, what prevents you from being a fair and impartial juror on this case? Could you detail it?
Well, I have to relate back to my experience and how it affected me in order to figure out how maybe the person felt if they had a gun drawn on them.
Sure. And so I don't want to imply that being fair and impartial means that you can draw on your own experiences to come up with to analyze the facts and analyze the situation. That's not what I'm saying at all. What I'm saying is, can you hold us to our burden of listening to the facts, listening to the testimony, listening to the evidence, and giving the defendant a fair and impartial analysis of that evidence in determining whether or not we met our burden to prove each of these elements beyond a reasonable doubt?
Probably not.
Thank you for your honesty. And that would be the case even if the judge so instructed, even if the judge instructed you to follow the law and be fair and impartial. You still do not think that that's something that you could do.
There may be a kernel of something in my mind that would reflect what my experience. Sure. That's all I can tell you.
And I'm being out, I just I have to stick you to this, I'm not picking on your problem. And again, the fact that, you know, this, you have experienced something similar, doesn't strike you as automatically, counsel out as a juror. But it's whether or not that experience is going to prevent you from being fair and impartial. And what do you think? If you're instructed by the judge to follow the law, are you saying you don't think that that's something that you could do?
Maybe I have to be put in the situation, sir. I'm not quite sure.
Okay, thank you, I appreciate that. What about you, Mr. Sullivan? Have you been, you or anyone close, you've been a victim of, or been in a situation someone has pointed a gun at you? Ms. Wright? Second question. A couple more questions here. Okay. So the law allows the state to prove its case by one witness. Basically saying the testimony of one witness is sufficient to convict a defendant. If, of course, the jury believes that the state has proved each element by that testimony, each element of the offense beyond a reasonable doubt. Does anyone have an issue, or please raise your hand if you have an issue with convicting a defendant with only the testimony of one witness? Will anyone need multiple witnesses? Like, I'm just not sure. I'll need to hear 2, 3, 4 people say the same thing before I'm going to give it any type of credence. Mr. Or Ms. Ezell, what do you think about that? About potentially convicting someone off the testimony of one witness?
I feel like I would have to hear multiple stories that we can address with that.
Okay. Even if the law provides that the testimony of one witness, if you believe their testimony is sufficient to convict the defendant, are you saying you would still need multiple stories?
I guess as long as it has, I mean, if it has enough, then it does, if it doesn't, then you have to.
Mr. Davis, what about you?
I think I would have to look at the whole situation, analyze public need more facts.
Sure. Let me go a little further on that. What do you mean by you would need more? Are you saying that you would need additional testimony? Or is it enough that you believe, you know, hypothetically, if you believe that witness beyond a reasonable doubt, and there were no other witnesses that testified, if you believe that witness beyond a reasonable doubt as to the state, each element of the state's case, could you then convict, or would it be like, I only heard from one person, so I can't believe it?
I'm gonna be honest, I would have to look at the whole entire situation. Like I said, I can't really say that I would just automatically leave that one person.
Sure.
Unless, you know, the facts turns out to where they're telling the truth. You know, I would probably go.
Okay. Thank you. Mr. Dupuis? Where am I at? Oh, what about you? Could you convict off of, one witness if you believe that witness beyond a reasonable doubt?
I'm not totally sure. I would think that it would require more, but, I guess I would just have to hear the facts.
Sure. So is it the number of witnesses that's the issue, or is it, you're just unsure about the what is going to be said or the evidence that's going to be out there? Which one? Because I think those are two different things. If the issue is, well, no, I just need to hear from more than one person, or if the issue is, well, I just need to hear a sufficient amount of evidence.
Yeah, I'm really not sure, at this point.
Sure.
I don't.
Sure. And we haven't put on any evidence or anything like that. Anything I say, all this is not evidence. Again, I'm just asking questions to get a feel of how the jury feels. And I just have to get you committed on either way, on this question of whether or not you will require more than one witness. Even if you believe the one witness beyond a reasonable doubt, you believe that they were telling the truth beyond a reasonable doubt, believe the testimony, and you believe that their testimony proved our case beyond a reasonable doubt. Are you saying that in that situation, you still would want to hear from someone else before you author it? Thank you. What about you, Ms. Henderson?
I think I agree with that, yeah.
Okay, I anticipate this is going to be a fairly, straightforward and simple case, albeit very, very important. I would imagine that testimony will probably wrap up tomorrow, afternoon. So I want to thank you for sitting here and speaking with me for 3 minutes, as I, try to get everything ready to question this case, and, we really appreciate you, the court, I really appreciate your service, and you showing up to do the public. Thank you.
Mr. Robot,
Thank you, Your Honor.
you may proceed.
Please, court.
Yes.
Guess you figured out this ain't my first rodeo. Let me brag on myself a little bit. April the 16th, I will have been honored to have been a practicing lawyer for 50 years. I've toiled down in this courthouse virtually every week that last 50 years. Won some, lost some, done well sometimes, not so. I practice criminal law, I practice personal injury law, I practice real estate law. I've been a resident in this area since I was a little legal. It's an honor to be able to work in this system. But it only works if y'all, it only works if y'all do your job and if we do right. So I'm gonna do my best to try this case ethically and honorably. I believe in what I do. Sometimes I get a little lathered up, so y'all excuse me for being there. Let me tell you, how many of y'all have been on the jury before? Some of you been on civil juries, some of you been on criminal. Right? Who's been on both? You understand there's a different burden of proof in the two kinds of cases. Civil case, you probably saw a lawyer stand up here and say, my burden is to prove that it's more likely than not that an event happened. Now, all I have to do is tilt. You probably saw somebody do that, right? That's not the way it is in a criminal case. Burden of proof is on
state of Texas, all the way through the case to prove every element of what they claim beyond a reasonable doubt. We don't currently have the definition of what beyond a reasonable doubt means. Mr. Johnson didn't give you one because there's not. A few years back, the Court of Criminal Appeals, great state of Texas, decided, well, we are going to give folks on the jury the definition of what beyond a reasonable doubt is, so that will help them decide. And then they decided later, well, no, we're not going to do that. You're not bound by what I'm about to tell you, but it might give you a sort of a yardstick to think about when you're back in the jury room deciding this case. So what we used to define it as would be that degree of evidence upon which you would rely in making the most serious of your everyday decisions. Does that make sense to you? Is that something that you would kind of say, well, that makes sense to me. If I'm going to decide if somebody's going to be convicted of a crime that they might go to jail for up to a year, it ought to require some pretty good evidence. Right? Everybody agree with that? So that's concept number. The other concept is what we call presumption of innocence. Anybody know what that means? Mr. Davis?
Presumption of, I just zooming in there.
Right. Means that as we sit here, my client, Mr. Wilran, is presumed to be innocent. You know how you get charged with a misdemeanor in this state? You think a grand jury meets and considers evidence, and listens to it, and then makes some kind of vote? You know what happens? Some guy goes down and signs an affidavit who works for law enforcement, who investigated the case and said, I think I can. And that's how we end up. It is no evidence. Anybody think just because Mr. Randall was charged with crime, that is somehow some evidence? I'm assuming you're all going to tell me. No, Mr. Dupuy, you agree with that? Sure. All right. I gotta ask this question because it's in the Code of Criminal Procedure, and if I don't ask it, I haven't done my job. There's a provision in Code of Criminal Procedure that says that if you've made your minds up, any of you, as we said here, that Mr. Randall was guilty of something, and that would affect your verdict, kind of like you, sir, then that's not good. And you probably shouldn't be on this jury. Mr. Burton, you made your mind up? Anybody made your mind up? Anybody think here, as we said here, is right? Because he's charged with crime, somehow he's. I'm gonna pick on Mr. Dupuy, since you got asked a question about one witness. Who else? Mr. Bell. You get to, I'll pick him. Law says that, yeah, you can have the testimony of one witness. be sufficient. But I can see that y'all are kind of saying, well, wait a minute, that's kind of difficult. The judge is gonna give you, I anticipate Judge Holmes will give you instructions that says that you are the sole judges, folks, of the credibility of the witness. So let's carry this one witness thing a little further. You would like that witness to be believed, right? That's what you're talking about. Because if witness is believable and her story makes sense, then yeah. Well, what happens if that witness is not believed? Right, exactly. So what happens if that witness has told more than one story about what allegedly happened? That'd be something you'd want to know about, right? Mr. Kozlowski? That's you, I'm sorry. Right? For example, she said one thing happened and we got video evidence that another thing happened. That would make you scratch your head and say, wait a minute. Maybe she's making this up. Or if she was motivated by ill will, that would be something you would want to consider. Right? Axe to grind. There are, let's see, where you work, fire department. You got anybody else who works law enforcement? You don't technically work law enforcement. But we in the free world think they kind of. You did.
Good race.
Yeah, okay. Well, you can appreciate, as I stand here, I'm thinking, well, I didn't tell you this story, but about to. The alleged victim works for Jefferson County Sheriff's Office. She wasn't on duty when this supposedly happened, so we don't have that issue. And their next door neighbor is a minor. So you can see how I would be concerned, Mr. Burton. If you might say, well, because I mean, you see police officers a lot, all the time. So you can see, I would be concerned that you might have a bias. You might believe them more than somebody else, or you might believe them when you probably shouldn't believe. Make me feel better. I mean, is that a legitimate concern?
I mean, I guess in other cases, yes, but.
So the question I gotta ask is, would you give this alleged victim comes down here and says he pointed a gun at me and with nothing more, no gun, no video, just that testimony only. You're gonna just, because she is.
Objection, Your Honor, to make the question.
Okay, objection sustained.
If there is no corroboration, argument's sake, you're gonna give that alleged victim.
Objection, Your Honor, still a commitment question.
Well, I don't think he finished asking the question.
Yes, sir.
Mr. Roebuck, would you rephrase your question?
Would you give that supposed victim more believability than somebody else? Would you think a police officer would make something up?
It's possible.
Okay?
Possible.
Is it solid?
Solid.
Yeah, did I get that right? Did you know Ken Lewis? He was over at Trinity. I noticed you're on the board of trustees. Sounds familiar, but I don't know. He died, he was my law partner, and I just thought maybe he might have. Where, Lauren? My wife works. I was curious about people.
I started in admissions and then I was in hospital.
Where'd you retire from, Mr. Duke?
Clean Marble Environmental Services.
That didn't help much. What did you do?
I was, vice president of the industrial service group for the Gulf Coast.
Gotcha. I have filed, I believe the evidence is insufficient to find Mr. Randall again. I think you're gonna find it. But one of the requirements I have to do in trying to select a jury is if we ever got the function, I have to make sure that I get folks that are fair and impartial. And that are not hanging juries. In an appropriate case, who could not consider the minimum sentence? I'm gonna tell you what the punishment range is. Punishment range is up to a year in jail, 0 to 1, and a $4,000 fine.
Objection commitment, Your Honor, and also, Your Honor, I believe. I would seek a motion.
Application of the jury assessed punishment.
We're approaching on.
Yeah, let's do this here. She has to come up. Ladies and gentlemen of the panel, could you follow the bailiff outside, and then we'll actually come back in a few moments. Let me do this here. Y'all can be seated. Oh, I was talking about I saw that one juror standing up. I mean, the panel, when you come in, you could be seated. Okay. You could be seated. Let the record reflect that the court is back in session at cause number 331-042, case style state of Texas versus Leo Randall Jr. Let the record also reflect that the jury panel is back in the courtroom. Let the record reflect that the defendant is present with his attorney and the state is present with their assistant district attorney. Mr. Roebuck, the panel is yours. You may proceed.
Thank you. You're Mr. John. Okay. You got the name wrong. I'm sorry. All right. As I was saying, range punishment is fine of 0 to 4,000 up to you're in jail. Or. So, can you consider the minimum and the maximum? Who could not consider that full range? All the way from $0, $1 to 4,000. All the way from no jail time to 1 year. Anybody on this panel, Mr. Burton, did not consider.
I consider the whole range, what you're saying?
Right.
I mean, I can consider the whole range. I think there's no. Hard to. I mean, whatever ends up being, what ends up being.
Well, whatever it ends up being is what.
Well,
You're
we
gonna
decide.
what you're gonna say.
But I mean, I can distinguish that right now. As of like. If he's known, gives maximum what. That's kind of that little.
I'm not,
I mean,
I'm confusing myself. I'm not trying to, I'm not trying to lock in.
Yeah,
I'm trying to see, if I got a guy that said, all I could consider would be $4,000. Or do I have a guy that says, all I can consider would be $1?
yeah,
They're not gonna like that.
right?
I'm sorry, what?
The full range of correct.
Everybody on board with that? Law says that there's no requirement that an accused present any evidence whatsoever of any kind. Anybody will require it. Would you require that? Describe possible. Would you require that an accused present evidence of his innocence?
It would be nice, but if the law doesn't require it.
Okay, all right. So suppose we don't. Are you gonna hold that against my client because he didn't present evidence of his innocence?
I'm gonna do what the law requires. The law doesn't require evidence.
Okay. Good. You Dale? What do you think about it? Would you require evidence of innocence?
if it's not necessary, then.
Well, we carry that a little further. It's highly unlikely that I'm gonna let my client testify. Law says can't consider that against him. You'll be instructed that you can't consider that against him. Who would? The federal? Would you?
Me. One.
So you would require, you would hold that against him if he did not testify.
I'm saying that I would hold that against it, but me, I would like to see something.
So you would like to see some evidence of innocence. So you then would, let me put it another way, would you require it?
I would require it, but what I'm stating is some, type of evidence. would be good,
Well,
if possible. If possible.
all right, remember what we talked about, presumption of innocence, remember that?
Sure.
And you told me that you would follow that presumption. Kind of looks to me like you're saying, well, maybe not. I can't look inside your head.
Right.
So you're gonna require evidence of innocence.
But the law that requires,
Law doesn't require, I'm telling you, it doesn't require. Or are you gonna require? I think that's a yes.
I think, yes, I just have to.
Mr. Jones?
I'd like to see all the evidence. I mean, if it were me and I thought I was guilty, I would tell you. I'd get up in court and say, give my side of the story. Then we gotta go and one be here two different sides and, you know, I make my decision on that.
But there's not two different.
But what is the circumstance? I mean, you know, we don't know what happened. Was he defending himself?
So. Looks to me like you're saying, I'm not so sure that presumption of innocence is that big a deal to me, because I would require. If the proof is not there, I would still require testimony by the accused.
Yes.
You would?
Yeah.
Okay. Who else feels it? Now it's time. This is the only time in this trial that you have the opportunity to kind of interact with us. Because when after you get over there, you can talk. So anybody else? Or I'll pick on you.
That's fine.
I'm sorry.
You know, law says you don't have to do it, you don't have to do it, I'm not gonna hold it against someone, and you get it.
Too quick.
They have to prove their case, so he's innocent until then.
That's it. Exactly right. Okay. I don't know if I've taken up my 30 minutes, but I'm sure you're all tired of listening to me. I appreciate the time. We're gonna, so and let me say this, for those of you not been on the jury, there are different kinds challenges. The challenges cause, and there's what we call peremptory challenges. So, peremptory challenges, we each get three, we can strike three of you because of any reason or no reason. So I know for those of you that have just got a burning desire to be on this jury, if you don't get picked, there's no rhyme or reason to this jury selection business. You might make a decision because we don't like the way somebody looked at it. So don't get stinged, sir. You don't get on. I appreciate the time.
Okay, ladies and gentlemen of the jury, we're gonna ask that you step out into the hallway, follow the bailiff. We may require some of you to come back in to do some follow-up questions. So at this time, you can step out into the hallway, court will be in recess.